application in the matter of Municipio de Mariana and others and BHP Group.
Yes.
I appear for the appellant with Mr. Oliver Butler, Mr. Daniel Burgess, Ms. Tamara Kagan, and Ms. Veena Srirangam. The respondents are represented by Mr. Alan Chu Choi, King's Counsel, Mr. Andrew Fulton, King's Counsel, and Mr. Jonathan McDonough.
Yes.
My lords, before I turn to each of the 5 grounds of appeal, I want to start with 4 points by way of brief introduction.
Right. If it helps, I can tell you that we have read the skeleton arguments, we have read the judge's judgment, and we are familiar with the principles that an appeal court applies in appeals on fact, including findings of foreign law.
My lord, I'm very grateful. Could I then just turn to ground 1.1? I was going to cover some of those principles in the introduction, but perhaps I can just start with ground 1.1.
Yes.
I'm going to take 1.1 and 1.2c together.
1.2c.
Yes, because both of them are about the interpretation and application of environmental law. 1.2c is causation, so it does step into some issues of fact as well, but I'm going to address the legal points together. My lords, on ground 1.1, which is polluter definition, there were 4 key issues in relation to the legal test for polluter liability, and we have set them out in our skeleton at paragraphs 23 to 26. I'm going to address each of them in turn and submit that BHP have a real prospect of success in demonstrating that the judge's findings on each of those issues is contrary to the agreed expert evidence and the material supporting that evidence, or alternatively, that the judge failed to engage with BHP's submissions. We're going to take the first 2 errors together. So that is the distinction between direct and indirect polluter and the meaning of direct polluter. Can I ask the court to please start by looking at the text of the environmental law? And if you take it from the judgment, paragraph 289, that's in the core bundle, tab 6, page 59. So that's PTA 1C/6/59. Article 3.4 describes a polluter as a person who is directly or indirectly responsible for an activity. And the core issue between the parties was what test applied to determine whether a party was a polluter. And one of the key disputes between the experts in their written evidence was over whether there is a distinction between direct and indirect polluters. That is an important dispute because much of the analysis cascades from it. And if we could start by looking at BHP's expert evidence, which is summarised in the judgment from paragraph 272, so that's PTA 1C/6, and it's page 52. So set out from 272 to 274 is a summary of the evidence of both Professor Malare, who was BHP's expert before he had to pull out of the trial on grounds of ill health, and Professor Dantas, who took over. And they approached polluter definition by noting the distinction between direct and indirect. The distinction is that the direct polluter is the operator or doer of the activity that causes the environmental damage. And this person can simply be identified as a matter of fact. And from 274, so that's over the page, you can see that they said that the indirect polluter is the person who has a duty of safety vis-a-vis that activity and breaches that duty. And the identification of that person requires first a consideration of whether there is a legal duty of safety in relation to the activity, and if there is, whether or not they have failed to comply with it. And it's also necessary, as 274 makes clear, that there must be environmental damage and there must be a direct and immediate causal link between the omission to comply with the duty of safety and the environmental damage. And as I said, I will return to causation when I look at ground 1.2c. Now, in his written evidence, the claimant's expert, Professor Sarlett, did not accept that there was a clear distinction between direct and indirect polluters. Rather, he said that polluters were identified using a single multifactorial test, and his written evidence is summarised in the judgment at paragraphs 264 to 265. So that's PTA 1C/6/51. So, my lords, that was the dispute on the written evidence. When Professor Sarlett came to give his oral evidence, he did accept that there was a clear factual distinction between direct and indirect polluters. And that evidence is summarised, it's quoted in fact, in the judgment at 294. So that's PTA 1C/6/60. And you can see the two passages quoted in paras 294 and 295. And in our submission, those passages make plain the concession that he accepted the factual distinction between those two categories and the judge's error. But these...
Well, I'm just going to interrupt you on the concession point, because in the schedule of corrections which was submitted by the respondent, there's quite a lot of cross-examination on this specific point, which isn't referred to either in your skeleton or indeed in the judgment, isn't there?
There certainly was a dispute, my lord, about Professor Sarlett's evidence.
I don't think that's quite the point I put. What I said was there's quite a lot of cross-examination on this point.
Yes.
In addition to this.
Yes, I was just about to show you the additional bits in our written closings. These two passages demonstrate in my submission that he accepted the distinction. I'm going to come on to deal with what the judge says about it. And I was just about to say that these are not isolated instances. And we've set out in our closings, this is our written closings for the trial, further parts of his oral evidence where he accepted that distinction. Could I just show you that? It's our written closings, which is in the supplementary bundle at tab 18, if my lords are working from the hard copy, and it's N2/1.1/63 to 64.
Sorry, give me the page again.
N2 1.1 63 to 64, my lord. And it's paragraphs 174 to 177. I don't know if it's possible to have two pages up on screen so we can see them side by side.
I do apologise, it's taken quite long.
That's okay, thank you. So the evidence that we put in the written closings, as well as the excerpts in the judgment, we say support the distinction. The judge did not engage with the further evidence that I've just shown you in our written closings.
But there's also other evidence in there that isn't in your written closings, which was produced in the table of corrections.
My lord, yes, and as I said, there was certainly a dispute between the parties as to what Professor Sarlett said and what it meant. And the evidence that I've identified shows clearly that he did accept that there was a factual distinction between the two concepts.
Well, does he not say at the judge quotes at 295, for liability purposes they're made equivalent, there's no difference between them in terms of equivalence for liability.
Yes.
They're only different in terms of degree.
Yes, and my lord...
Well, degree is not conceptual difference, degree is degree.
It is, and can I just say, the word concept may have clouded the issue. The point I'm making is he accepted the factual distinction, which he clearly does in the excerpt that my lord has just read out. He did indeed go on to say that they're joint and severally liable and so on, but that was never in dispute. The question I was asking him was whether they are different as a matter of fact. And if I can just develop this, because
Just before you do though, when you started your submissions on this, you were presenting it to us as a concession, I think.
It is.
Your expression was that he conceded,
yes,
but there was no difference.
he conceded that there was a
Sorry,
distinction.
that there was a distinction, which
Yes.
was your case.
Yes,
But the passage which my lord's just drawn your attention to is one of the things we've got to do is read that answer, decide whether it amounts to a concession or not.
yes, and it's the first part that I'm focusing on for now.
The
There-
first part of what?
So if you look at 294,
Yeah?
do you agree that there can only be an indirect polluter if there's a direct polluter? He says, yes. My answer is that as a rule, we have a direct and an indirect polluter. We can only have an indirect polluter if we first have a direct polluter, I ask him, and he says, yes, that's the rule. So he accepted that you have to have one to have the other. Then I go on to say that there can only be an indirect polluter if there's a direct polluter. He says, yes, that's exactly it. And I then say, it follows, doesn't it, from that sentence that a direct polluter is a separate concept from an indirect polluter. And all I'm asking my lords to look at for now, I will come back and deal with the other point, is he says they are only different in terms of the degree they are linked to the activity and the activity that caused the damage. If we could just stop there, because the liability purpose is a different point. There was no debate about that. And what I was trying to get him to accept, which he did accept, is that they are factually different. That is it. That was what I was trying to get, because he had not said that in his written evidence, and he said it orally on a number of occasions. Now, the reason that mattered is because once you accept that there is a factual difference, the question is, well, how do you then identify the direct polluter? And that then leads to his second concession, which was that he agreed that the direct polluter is the operator or the exploiter or the doer of the activity. And he agreed that again in terms on a number of occasions. Now, the word can vary. I preferred operator, he preferred exploiter, but you can see that there was agreement about the essence of the issue, which is that the direct polluter is doing the activity. And could I just ask you to have a look at that? That's again in our written closing at paras 180 to 183. So if my lords are using the supplementary tab 18 version, it's pages 65 to 66. And it's N2/1.1, 65 to 66. So if I can just ask you to have a look at those 4 paragraphs. And you can see there,
Just remind me of the paragraph number. It's 180.
180, my lord, is the start, and it goes to 183. And he says in the underlined bit, our difference is, well, I can agree that a direct polluter, and here we are thinking about a distinction between direct and indirect. A direct polluter is the one that causes damage exercising an activity. Later, he suggested he would prefer to use the word exploiter, but ultimately accepted that this is just another way of saying they were doing the activity. And you can see the evidence there. And then 183, he accepted that in the world of licensed mining activity, the operator stroke exploiter, and thus the possible direct polluter, was the person who holds the mining license. at the end of that extract, I ask him, so you will agree that if I hold the mining license in the context of licensed mining activity, I am the exploiter or operator, as I would prefer, but you would prefer exploiter, yes? Yes. Now, the reason that these two concessions matter is because they undermine the suggestion of the singular multifactorial test that Professor Sarlett's written evidence had addressed. And that is because, first of all, there is no need for any test, let alone a multifactorial test, in relation to the direct polluter, because the direct polluter is simply the person doing the thing. So you don't identify the direct polluter by reference to multiple or varying factors. It's artificial and wrong. It's just a factual question of who's doing the activity. And the second reason
Well,
that
wait a minute. Is that right necessarily? Professor Sarlett prefers exploiter to operator. You put to him that if I hold the mining license, I am the operator, I am the exploiter or operator, and he says yes, but does it follow that the holder of the mining license is the only operator or exploiter? That's not in your question. You're
well,
not saying that that is to the exclusion of anybody else who might be regarded as an exploiter or operator.
well, my lord, that's a slightly different question to the meaning of his concession. And the point I was just making
Oh.
is,
But you were saying that having agreed the proposition you put to him,
yes,
there was no room for a multifactorial test, but I can't see that follows from this particular
Well,
dialogue.
there's a separate question as to whether or not there's anybody else. But that I will come on to. But right now, I'm
And
just,
that might be a multifactorial question.
well, it might be and it might not. But the reason that this matters is multifactorial is what it says. You look at a range of things. The reason it mattered to get him to accept that there's direct and indirect, and indeed to get him to accept that the direct is the doer, is because, as I've said, that then cabins that particular figure. We're still left, absolutely, with the question of who else might be responsible, and I'm going to come on to that. But that cabining is the first step in this need to cascade the analysis. So that's why I say that concession mattered. And the second reason it mattered is because you then ask yourself, well, who else is there? And that then comes on to whether or not his test applied to the indirect polluter figure. So we've agreed that direct is the doer. We also agree that there can be others liable. And the question then is, how does one identify them? And the question further on is, does one use his multifactorial or does one use BHP's breach of duty of safety? So it focuses the dispute. Now, could I just deal with, before I come on to duty of safety, with what the judge found?
Yeah, but just before you do that, because you do insist when I raise this point where you're saying concession, for us properly to decide if it is a concession or not, notwithstanding what you've put in your written closings of the trial,
Yes.
we have to take his evidence as a whole, don't we?
Yes.
Yeah, and if one looks at some of the passages of his evidence on this specific point in the respondent's correction table, which, as I understand the sequence, I might be wrong, was put in to correct what they said was effectively the way that you presented what Professor Sarlett had in fact said in cross-examination. We have to look at all the passages of how he answers this question, don't we?
Well, my lords, you do, but can I say this? In my respectful submission, this court is not going to be able to resolve the many differences between the parties as to what Professor Sarlett said, and indeed what other experts said, and indeed, as we'll come on to look at, whether or not the claimant's pleadings were in fact reflective of the case that the judge adjudged. There are lots and lots of disputes at a very granular level.
Well, yes, I was puzzled by that, looking at your skeleton argument, when you said there's got to be a retrial, but it's got to be done on the transcript, and there's no need for further oral evidence. Now, if that's right, if it can all be done on the transcript,
Yes.
then this court is in as good a position as any trial judge to do it. I don't understand.
My lords, absolutely, but there's obviously a difference between this hearing, where I'm
Of
trying
course,
to
this is
get
only-
permission.
I follow that.
Yes, but-
if we were to give you permission to appeal,
Yes.
but if your appeal were to succeed, why does this court not make the decision rather than sending it back to another High Court judge who's only going to look at the transcript?
Well-
I didn't understand that at all.
Well, my lord, let me clarify. We do want this court, we most definitely want this court to resolve ground 1.1. So the reason I'm resisting my Lord Justice Fraser's question about the granularity of, well, they said this and we say this, is my point is at this permission level, I'm not trying to persuade you. I want to show you that there's a real prospect that I will be able to persuade you if in a few weeks or months I'm here arguing before you that ground 1.1 was plainly wrong. The judge did make a mistake. At that stage, I will be inviting you to roll your sleeves up and please follow me through the transcript.
No,
So the
but
point-
Ms. Fatima, you, with respect, you must have misunderstood my point. It's where we've got two parties, one of which says, one of whom says, there was a concession by this expert on this important point.
Yes.
And the other party, and look at this question and answer, and the other party says there was no concession. So the first thing we have to decide, it's not as if this was a point in an expert's agreement that had been discussed and agreed and signed off by the experts. You're relying on parts of the oral cross-examination to say there was an important concession by the expert.
Yes.
On the basis the respondents say there was no such concession,
Yes.
the first thing we have to decide, don't we, is was there a concession or not?
My lord, no, with respect. I'm
So
not
we don't have to decide
not
whether
at
there's
this
a
permission stage, no. With respect, at this permission stage, I would submit you need to ask yourself whether or not I have a real prospect in showing you, first of all, that the judge erred in 1.1. And this point about the direct, indirect, as I will show you, is a starting point to that analysis. It's by no means the basis on which everything rests. And the other reason why I'm not asking this court to resolve it is because the other way that we put ground 1.1 is, as the court knows, failure to engage. And what I want to show you is what the judge didn't take into account, and we say wrongly, because they were central arguments and submissions. And so part of the reason for showing you the additional evidence in our written closings, and indeed I'll show you more, it is to say the judge should have addressed it, even if she was going to find against us, because the evidence was, we say, compelling, she should have told us why we were going to lose. And so, my lord, for those two reasons, in my submission, this court on this permission hearing doesn't need to decide one way or the other whether or not the evidence supports me or whether it supports my learned friends. It's whether or not I have a real prospect of showing you that the judge was wrong in everything she did with ground 1.1, of which this is a small part, and it's whether or not I will show you in due course that she did not take into account our central arguments.
Strikes me as an ambitious submission to say the judgment that runs through over 1,100 paragraphs is short on reasoning.
My lord, I hope I will be able to show you that. I'm conscious I have a lot of material to get through, but that is indeed the submission. And the court will have seen that it's a submission that spans all 5 grounds of our appeal. And that's partly why I'm anxious to show you the architecture of the judgment, rather than get stuck in little details, because there are a lot of little details that one can get stuck on.
I don't think direct or indirect polluter is a little detail, though, is it? It's quite fundamental to your case on 1.1.
Well, it depends what my lord means by direct, indirect. There are a number of layers to the argument. So I'm at the moment just in the very first layer. The most critical layer we'll come on to is indirect polluter. So I'm just trying to build my way up to that. But going back to the 2 concessions, I've explained that with the first, it cabined the idea of what the direct polluter is, how we identify it. But then second, it means that the question becomes focused to saying, how does one identify the indirect polluter? Do you use Professor Sarlett's multifactorial test, or do you use BHP's breach of duty of safety? Now, I was going to explain to you what the judge found, and the judge found that Professor Sarlett maintained his position that there was no conceptual distinction, and we see that in the judgment at 324. That's PTA 1C/6/78. And in the consequentials judgment, the judge says that BHP put their case on the conceptual distinction between direct and indirect responsibility to Professor Sarlett, and he did not accept it. We don't need to turn that up, but the reference is paragraph 64, Roman 4. And in our submission, the judge appears to have misunderstood the evidence where he accepted the distinction, possibly because of the use of the word concept, and possibly because of that latter part of his answer where he talks about the consequences. And as I've said, there was no dispute about the consequences, and I wasn't trying to get him to deal with the consequences. It was that factual distinction that mattered. And there is nothing in either paragraph 324 or elsewhere in the judgment about his acceptance that the direct polluter was the operator or exploiter or the exerciser, or his evidence about the importance of the license holder vis-a-vis mining. So that is evidence that is missing from the judgment. Now, in our submission, it's significant that the judge didn't deal with our submissions on this distinction properly, because there's no basis we submit for the finding that we see later in the judgment at 523 that BHP are directly responsible for the activities of Samarco. So, my lord, those were the first two errors that we say that the judge made. Could I just, before I go to duty of safety and indirect polluter, could I just pick up two brief points in response to the claimant's skeleton? First of all, at paragraph 11, they say that the judge's views were based not only on the expert evidence, but also on the proper interpretation of Article 3.4 and the STJ case law. That is a bad point because the interpretation of Article 3.4 and the STJ case law were considered in detail as part of the cross-examination and therefore as part of the expert evidence that you've seen. And then in paragraph 12, they dispute what Professor Sarlett said or meant, which is, my Lord Justice Fraser's point to me. And as I said in answer there, the court will have seen that there is a long history of the parties disputing what evidence was given and what it means. Our point is simply that it is plain from our closings that we regarded Professor Sarlett as having made important concessions. And in our submission, the judge ought to have engaged with that material, and she did not, other than that reference that I've shown you in paragraph 324. Now, we see that omission, that failure to engage, much more starkly when we come on to duty of safety. And that is really the heart of where the problem lies with polluter definition and the judgment. So here we say the judge should have found, in light of the agreed expert evidence, that BHP could not be an indirect polluter because they did not owe or breach a duty of safety. And we've addressed this in our PTA skeleton at paragraph 25. Could I show you what the judge said about this? She addressed it in the conclusions section, and that's paragraphs 328 to 329, PTA 1C/6/78 to 79. So if we can have 328 and 329, if possible, thank you very much.
Was that a sixth conclusion? Sorry.
My lord, yes, the 6th and the 7th. So these two paragraphs contain the judge's conclusions, but it is not clear what evidence she has had regard to in coming to those conclusions. And so our first point is that contrary to Symetra, she hasn't marshalled the relevant evidence and then given reasons why the evidence is either accepted or rejected. She says nothing at all about Professor Sarlett's oral evidence on duty of safety. She refers to the fact that Article 3.4 does not contain any reference to the duty of safety, as if this is a point against BHP, but the judge herself recognises earlier that it is necessary to consider the case law and other legal materials because Article 3.4 does not contain guidance on what constitutes direct or indirect responsibility. And for the court's note, that is at 296. And then finally, BHP relied on case law and doctrine in support of its case on indirect polluter liability. But the judge says nothing at all about the doctrine relied on, and we submit doesn't engage with our submissions on the case law either. Now, we can see in 329 that the judge finds that there is no consistent case law in support of such requirement, that is, the breach of duty. My lords will see that in the second and third lines. We submit that as contrary to the agreed expert evidence, and that is what fails to deal with Professor Sarlett's oral evidence. And there were 4 key strands of that oral evidence. Can I just give you them and then I'll develop them a little bit? So first of all, Professor Sarlett accepted that someone could only be liable as an indirect polluter for an omission if there was a specific duty to act on them. And the same rule applies to public entities. And these 2 points are based on STJ case law, the Vicuña and Jacuparanga. Second, he accepted that there were many cases below the STJ level which said a legal duty was indispensable for indirect polluter liability. And he could not identify any cases which had considered the duty and said it was not needed. The third strand was he accepted that a considerable number of scholars had said that indirect polluter liability required a duty of safety.
Well, the reason I'm pausing, and it might be axiomatic or difficult, your second submission has been recorded in the transcript, is he says a legal dispute was indirectly dispensable. I don't think that is in fact what he
a
said.
legal duty was indispensable
That's how I noted it.
for it. I'm very grateful.
An extra indirect has crept in. So it's a legal dispute was dispensable for indirect liability.
Indispensable.
Indispensable for
A legal duty was indispensable for indirect polluter liability.
Yeah, that's what I thought you'd say.
Thank you. And then fourth, Professor Sarlett accepted that in his 2023 evidence to the German court, he said a duty is needed for indirect polluter liability. So those are the 4 strands of his evidence. And my Lord Justice Lewison put to me that it was an ambitious thing to do to show that this judgment had failed to engage. My Lord, this is a critical failure to engage. I've identified these 4 strands for you. They were incredibly important and indeed central to the notion of whether or not BHP are indirect polluters. The judge does not refer to them at all. Now, we submit that each of those needs to be considered in turn. Can I just try and go through them as quickly as I can? First of all, in terms of what the STJ has said about indirect polluter liability in the Vicuña, this was a judgment, as my lords may have picked up, of a 10-justice panel, and therefore important and authoritative. If we look at 336, which is PTA 1C/6/60, that sets out what Justice Cueva said in that case.
I think it's /80.
Oh, I'm so sorry. Did I say something else? Oh, I meant to say 80.
Yeah.
So you can see the passage that's set out. If I could ask you just to have a look at that, please. And in particular, not reasonable to also affirm that the liability of the appealed parties would be a logical result from possible omissive behaviour, as this, as known, is only verified in cases in which the agent, supposed polluter, having the duty to prevent degradation, it still fails to do it, benefiting, if indirectly, from the behaviour of a third party directly responsible. Can I show you our written closings, paragraph 206, that's the supplementary tab 18, page 70, N2 1.170. And you can see that I took him to that passage and I put to him that this is a general statement by him, isn't it? He responded, yes, that I agree with. But evidently, in order for there to be a relevant omission that leads to liability, be it a natural or legal person or a public person, there needs to be a duty to act. That is correct. So he accepted that this extract from the vicuña indicated the need for a breach of a duty. And indeed, he went on to accept that liability for an omission would not be a reasonable logic result if there wasn't a legal duty to act. He had not previously said that in his written evidence. And going back to my Lord Justice Fraser's point about the table that the claimants put in, my Lord, they accepted on this point, and I quote, Professor Sarlett accepted that liability by omission requires the breach of legal duty, end quote. And that is a reference to their document, which is N318. Now, I hasten to add, because I'm sure it will be emphasised by the claimant, that yes, this is evidence about liability for omissions. But that is still important because indirect polluter liability will usually be for such omissions. And that obviously follows because indirect polluter liability is concerned with those who are not the operators. They're the ones that have a duty on them. And it will usually be the case that the alleged indirect polluter has failed to comply with that duty by omitting to do something. So by definition, indirect polluter liability cases are often omission cases. That's why this first strand matters. And as we've seen, the vicuña is authority for that proposition. Now, Professor Sarlett also accepted this in relation to public entities. And the case there is Jacuparanga. He accepted that a public body could only ever be held liable under Article 3.4 as an indirect polluter if it violated its duty of supervision. And that is clear from the joint expert statement. I'm just going to give you the reference, which is C15T7. And that's the ratio of the Jacuparanga case, which is another STJ decision referred to in the judgment at paragraph 298. So contrary to that paragraph I showed you earlier, 329 of the judgment, there were two STJ cases which were clear and consistent in saying that a duty of safety is needed for indirect polluter liability. And that was accepted by both experts. The second of the 4 points is that Professor Sarlett accepted that there are a number of cases below the STJ level, including the Brascombe case, which held that a duty of safety was required. And can I just show you our closings again on this point? If we can go to, it's page 71 of tab 18, N2 1.171. And you can see from 207.4, when I was asking him about the Brascombe case, that he said there were a number of decisions below the level of STJ which held a legal duty was indispensable. And if we can have a look at the next paragraph on the next page, he also accepted, you can just get that up.
I do apologise, the system is running slow.
My lords, if you're looking at it on the hard copy, thank you, you'll see from 207.5 that there was no other case in the materials before the judge which specifically considered the duty requirement and held that it is not required. And Professor Sarlett couldn't identify any. Now, in their skeleton, the claimants say, well, the judge didn't have to look at cases below the STJ level. That's their skeleton at 17. But our submission, as I hope the court has it, is there are those two cases, Bakunia and Jakuparanga. The significance of all of these other cases is that they confirm that that is clearly the right requirement, the need for the duty of safety. And so we say that his evidence on Brascombe and all of these other cases was compelling evidence contrary to the finding made in 328 and 329, and the judge should have grappled with it. Now, the third point I referred to relates to doctrine. And again, if we stay in our written closings, if we could go back to paragraph 207.3, my lords will see that Professor Sarlett accepted that a number of scholars considered that there needs to be a duty of safety. So I asked him, do you accept that many eminent scholars say that a duty of safety is required? He said, yes, of course. And when I say a considerable part, it's not one or two. It's a number of scholars with internal variations. And then he goes on to say, so it is true that a number of important scholars understand that it's necessary to have a legal duty. And the court will see again, if we go to 207.5, that he could not identify any doctrine which had considered whether a duty was needed and concluded that it was not. And again, we say this is important evidence that the judge should have grappled with. The fourth and final strand of his evidence that's missing from the judgment is his evidence on the TÜV case. This is the German case. Now, the claimants say, well, these are unrelated German proceedings, so they don't matter. That attempt at a dismissal of what is very important evidence, my lords, is unconvincing. Because as I've said to you, the evidence was given recently, 2023. It was given by Professor Sarlett, and it was given on this very question. So the German court asked him, as I will show you, and he answered on whether or not a duty of safety is needed for indirect polluter liability. So could I ask you please to have a look at paragraph 208 of our closings, which is page 72. So that's N2 1.172. And that sets out the question that the German court asked him. With regard to any liability arising from environmental liability, the court's current opinion is there must have been a breach of the duty of care. An indirect polluter is someone who, as a result of an act or omission, violates his or her duty of care and thus contributes to or facilitates the occurrence. A prerequisite is therefore also a breach of due diligence. And the question is asked, is this preliminary opinion of the court correct? Now, his answer, his written evidence, first of all, is in 209. So if you can see that over the page. This was his answer to the German court. If I could ask you just to have a look at that. You see the question that's there about the concrete example. So he said to the German court that the concrete supplier would not be liable unless a direct link is demonstrated. So you're saying you do need the direct link between the quality of the concrete and the dam failure, and he says yes, that's on the causal link. And then in 209.3, it was put to him that his clear answer to the German court's question, is this a preliminary opinion of the court correct, i.e. that a duty was required for indirect polluter liability, was yes, and he had not said no anywhere, and he accepted that. And you can see that A in the extract, yes indeed. So the German court asked him whether they were right in saying that there must be a duty for indirect polluter liability, and he replied to the German court and said yes, and he confirmed that in his oral evidence. Again,
But where does he say yes to the German court?
my lord, I don't know if there's a bit that you've missed from 209 in our closings.
Looking at 209.1.
209.1 is the beginning of his answer,
Yeah.
yes. So if I could ask you just to have a look at that again.
So he says, anyone through his or her omission or inadequate conduct
Yes.
contributes. So that doesn't say anything about a duty. And then he talks about a direct link, which also doesn't talk about a duty. So I'm just wondering where he says yes to the German court.
Well, it was the answer read as a whole was saying yes. He didn't say in terms yes. That's why I put it to him. When we read your
But
answer
you just told us that he did say yes.
to me, my lord, in the
You said
cross-examination.
He said yes to the German court.
Yeah, so I asked him, you're saying yes to the German court, aren't you? And he said yes. And that is in the extract from the cross-examination.
Where he says, yes, indeed, because you're now showing me the previous answer in this part I described, what I always refer to in my evidence, which this is not an infinite responsibility or liability
Yes.
chain.
I'm sensing that my lords are not persuaded by that evidence, but again,
Well, the difficulty I have, I'll be quite frank with you, is the
Yes.
difficulty I have is when you tell me something's a concession and I then look at the material and it doesn't necessarily seem to jump out at me as a concession.
Yes.
It's one thing if an expert agrees something in a joint statement,
yes.
but it seems to me that a lot of this is a different of emphasis on what the answer in fact meant.
My lord, I accept that there's a lot of nuance in this, absolutely. And that is why it is very difficult, as I said, to accept this court on a permission application to grapple with all of the nuance. I entirely accept that if we got to the point of having the proper appeal on this, I would need to persuade you that I was right about the nuance. But I'm trying to get something far more basic at this stage, which is whatever you might think of the merits of my argument, this was a central argument.
But don't we have to take a view on the merits of your argument ab initio in order to decide whether it's reasonably arguable?
Well, it's plainly arguable, my lord. I think it would be very difficult.
I don't think that's the test. The test isn't arguable, the test is reasonably arguable, isn't it?
Well, I am trying to persuade you that the court did not engage with a central part of my case.
I do understand that.
And so all I'm saying is the indirect polluter liability part of that is a central part of the case. And we do not see this evidence in the judgment. She was required to engage with it because of its centrality, because of the fact that we spent so much time on it in written and closing submissions. And if she decided that the evidence was not persuasive or was unclear or had not gone as far as we were saying it had gone, then she should have said that because of the centrality. So, my lord, that failure to engage, as I said at the outset, that is the overarching thing that we rely on for all of the grounds. The difficulty I have, of course, is I'm also trying to show you that it was plainly wrong at the same time. That I, of course, accept is harder, but on that I also say there is a real prospect. Because, of course, I'm required to show you that there is material, but I cannot show you all of the underlying evidence in the time that I have. Indeed, it won't surprise you to know that I'm far further behind where I had hoped I would be in terms of my timing. And I'm trying to give you a flavour of the issues so that you understand, first of all, how much has been omitted. And secondly, the fact that this was all argued at length. And so it was something that we say fairness required the judge to address. So, my lord, that we say was an important point that he made in his evidence, and the judge should have addressed it. But as the court will see, there are 4 points that I've made on duty. So I'm not relying wholly on the German evidence. There are the STJ cases, there are the cases below the STJ level, there are the considerable number of important scholars, and there is his evidence to the German court. And we say none of that was addressed by the judge. Could I deal with the fact that in the consequential judgment, in response to this point, the judge said that the defendant's case on the need for a duty of safety was put to Professor Sarlet and not accepted. And she then refers to paragraphs 314 and 317 of the judgment. The reference to that I just quoted was the consequentials judgment, para 64, little Roman 4. But can I just ask you to have a look at the paragraph she identified in her own judgment? And maybe we could start at 313. So that's PTA 1C/6/76. Now, just by way of a reminder, these are passages in a section which is headed Experts' Evidence, and it starts from 308. So if we can just have a look at 313 to get the context. So that's about Professor Dantas's evidence on the causal link. And you see that at the end of that paragraph, he describes his evidence that it is always necessary to identify a causation link between conduct, that is acts and omissions, and the damage. And then if we go over the page to 314, so this is now the start of the section the judge relied on. We see that that describes Professor Sarlet's evidence on the need to consider acts and omissions. And then this is all in the context of a discussion about causal link. You can see that from 315 as well, which is what Mangroves said about the need for a causal link between the defendant's acts and omissions. And then if we go down to 316 and 317, you can see that there's yet more about causal link. So, my lords, there is nothing in any of these paragraphs that we can see that deals with indirect polluter liability or the duty of safety, and obviously nothing about Brascom or the doctrine or the German case. So with respect, we do not understand the reference in the consequentials judgment to these paragraphs. And it appears the claimants do not understand either, because they are left making the implausible suggestion in their skeleton that these passages are dealing with the Benjamin statement, and Professor Sarlet's evidence about that covers the duty of safety. And they've said that in their skeleton at paragraph 14. But my lords, we cannot see the duty of safety here. That is what the judge has referred to. But in our submission, something has plainly gone wrong, because if these are passages that are intended to deal with the duty of safety, we do not understand what the judge has concluded. Could I just finally then address the fourth part of ground 1.1, which is the multifactorial test? And we've identified this in our skeleton at paragraph 26. This relates to the judge's finding in para 330, which is PTA 1C/6/79, that the STJ has in practice adopted a multifactorial approach, and the STJ cases indicate that the relevant factors are control, participation, financing, and economic benefit. The key point here is that the judge did not consider the agreed expert evidence on the underlying STJ cases. And in our submission, had she done so, she would have concluded that the cases do not support the existence of the multifactorial test, nor do they support the finding that these factors give rise to polluter liability. Can I start by showing you our submissions, because you will then see that none of the analysis or the case law that we ask the court to look at appears in the judgment. So if I could ask you again to go back to our written closings, that's the supplementary bundle tab 18. It's page 66, paragraph 187, and it's N2 1.166. And you can see from the end of that paragraph, these cases, this is referring to the claimant's cross-examination of Professor Dantas. These cases were relied on in Professor Sarlet's reports to suggest participation or involvement was sufficient to ground liability. In fact, they are simply direct polluter cases. And then my lords will see that we analyse over the following paragraphs 3 cases, Petrobras Cubitel, Liberian Ship and TAG. And you can see that we set out Professor Sarlett's evidence, which in short made clear that these were not indirect polluter cases. None of this is in the judgment. So this was one category of cases that he, Professor Sarlett, relied on in support of the multifactorial, and we were suggesting a completely different analysis. The other group of cases are the control cases. And could we go on to page 81 in the same document, paragraph 240, so I can show you how we address those. So again, we set out control, and the quotation is from the Benjamin statement in the Mangroves case. We see Professor Sarlett's oral evidence that the mere fact of being a controlling shareholder is not enough to give rise to liability. If we can go over the page.
Are we on page 81 still, or have we gone to 82?
The bottom of 81 and now over to 82, please, so you can see the rest of that section. And then if we go down to 244, I'm going to come back to the controlling shareholder point. 244, you can see that Professor Sarlett accepted that a number of cases that he relied on in support of control were not decided on the basis of control. And we then go on in the paragraphs that follow to deal with the Latina derailment, the chemical weeding, and the Rumo case. And again, for each of them, we set out where Professor Sarlett accepted that these cases were not imposing liability by reference to control as a factor. And again, the judge didn't include any of this in the judgment. And I could repeat this exercise for financing and benefit as well, because we considered those. But the key point is that Professor Sarlett accepted that neither financing nor benefit alone are enough to give rise to responsibility under environmental law. So again, we say these were important submissions. There was a lot of cross-examination on both sides on these cases, several cases as the court has seen. And we were saying that when you look at these cases, they don't support multifactorial, they don't support the grouping that the court eventually found. But the court has not engaged with any of that in the judgment. So we simply don't know what she concluded on our submissions. In their skeleton at paragraph 18.1, the claimants say that the court considered a number of STJ cases, and they rely on paragraphs 297 to 321. My lords, that is a bad point, because if you have a look at all of those cases, you will see that there is no discussion at all about which factors can give rise to liability. None of the cases that I've just shown you are referred to there. And in essence, what the judge does is she describes a bit about the case and then quotes from it. So there's very, very limited commentary. So we say that that point in 18.1 is a bad point. So my lords, those are the 4 aspects that we rely on for 1.1. Could I just turn very briefly to 1.2c? We rely here for the most part on what's in the skeleton. There are essentially 2 key errors. And I should just make clear that the assumption for this ground is that the judge was right to use the multifactorial approach. So we say that even if that is the case, she nevertheless made 2 errors when it came to causation. First, she failed to identify the right question. And the right question, which was agreed by the experts by the end of the oral evidence, was as follows. Did the defendant's acts or omissions cause the environmental damage? And instead of identifying that and then applying it to the fact, the judge asked whether the activity, that is of Samarco's mining, caused the damage. And we can see that from paragraph 332 of the judgment. The reason that was a mistake is because there was no dispute about that. And again, one sees that from 531 and 532. It's surprising that she failed to identify the right question because she records Professor Sarlet's evidence agreeing with BHP that the STJ in Vicuña had identified the need for that causal link between the defendant's acts and omissions and the damage. Can I just show you where she set that out at 335? So that's PTA 1C 680. So she sets out that evidence, but despite that, she doesn't say anything about BHP's acts and omissions causing the damage. Instead, she proceeded on the basis that there was no need for that factual causal link between the defendant's acts or omissions and the damage. But again, she didn't engage with any of our submissions on that being the right question. So having identified the wrong question, the second mistake we say that she made was by applying the wrong standard. And the standard that she applied was equivalence of conditions. It's not based on any expert evidence. We note at paragraph 55 of our skeleton that the judge wrongly concluded that equivalence of conditions applies. And indeed, she seems to have gone much further than the claimant's submissions in this regard, because she seems to have applied the pure version of equivalence of conditions rather than the measured or tempered version that the claimants were advancing. And we've noted that at 55.4 of the skeleton. And the court may recall that our argument was that the right causal standard is the direct and immediate test, which is in Article 403 of the Civil Code. And we'll come on to look at that because the judge considers it in the context of fault. We say that that was the right standard to be applied in the environmental law as well. So the two errors that the judge made in relation to the causal standard is, first of all, she didn't refer to Professor Sarlet's evidence accepting that Article 403 could be applied. That's the point we make in our skeleton at para 57. And second, she erred in concluding that the STJ decision in Vicuña supported the application of equivalence of conditions. That was contrary to the agreed expert evidence, and that's the point in our skeleton at paragraph 58. And we say that had she taken those matters into account, she would have concluded that Article 403 was the right test. So, my lords, that is ground 1.1 and 1.2c. Can I now turn to the application of the environmental law to the facts, which is ground 1.2a and 1.2b. 1.2a is the reliance on the controlling shareholder power, and we've addressed that in our skeleton at 29 to 33. Can I show you the test that the judge applied first of all? If we could go to paragraph 389 of the judgment, which is PTA 1C 691, you can see there that the judge found that, I quote, having and exercising controlling shareholder power does not more, without more, impose liability. And she repeats.
This is a 389 we are.
My lord, yes. 389, which is page 91. And she reiterates that at para 449, which is page 99. It is recognised that controlling shareholder power could be exercised simply through voting at shareholder meetings on high-level matters, such as strategic decisions, remuneration of officers and dividends. If limited to such matters, it is unlikely that without more it would give rise to responsibility for the activity of the company. So we can see from this that ordinary incidents of controlling shareholder power, the right to vote at shareholder meetings, the right to receive dividends and the like, they are not enough for liability under the environmental law. Rather, as she goes on to say in 449, controlling shareholder power could also be used at a more granular level in respect of the detailed business decisions and operations of the company. Just invite my lords to focus on that phrase. Exertion of such authority could give rise to responsibility for the activities of the company. So on the test found by the judge, liability under the environmental law can only arise if controlling shareholder power is used, that phrase I showed you, in respect of the detailed business decisions and operations of the company. So the relevant question on the judge's own findings was whether BHP actually exercised its controlling shareholder power in respect of Samarco's detailed business decisions and operations. And so, my lords, we say it follows from this.
Where did she say that?
It was in 449.
Controlling shareholder power could also be used at a more granular level in respect of detailed business decisions.
Yes.
Exertion of such authority could give rise to responsibility. So that's using your leverage as a shareholder to put pressure on the executives to make certain decisions. Is it?
Well, my lord, I would say she's saying it needs to go much further than that, because she's saying that it's the making of detailed business decisions and operations of the
Not by
company.
the shareholder. She's not saying that. Not in this paragraph. Right?
I'm so sorry, I didn't hear you.
She's not saying that it's the shareholder who makes the decision. She's not saying that in this paragraph. She's saying that the shareholder is using the shareholder's power
At a granular level.
to exert authority,
Well, it's...
not making the decision.
Well, my lord, she's saying controlling shareholder power could also be used at a more granular level.
Yes. If you, board of directors, don't do what I want you to do, then I will use my shareholder power to remove you from the board.
Well, we will come on to see how she's gone on to apply it.
But you were saying that she decided that there had to be actual decisions made by the shareholder. That's certainly not how I read paragraph 449.
Well, my lord, the starting point for this, you'll remember, in the environmental law, is the Brascombe case was authority for the proposition that an exercise of controlling shareholder power without more doesn't give rise to liability under the environmental law. That was Professor Sarlett's evidence, and the judge accepted that. And that is what I showed you in paragraph 389. So 389, she says in terms, having and exercising controlling shareholder power does not without more impose liability. So what she's then going on, given that that was common ground as a matter of law, is to say there needs to be something else. There needs to be the exercise, and it's that bit that was on screen, in relation to the detailed business decisions and operations of the company. So the question that on her own findings she identified was that the key point is that the shareholder power is in fact being exercised. The existence of it is insufficient. And the fact of it has got to be exercised, not to do the ordinary things you would do as a controlling shareholder, but to do the detailed business decisions and operations.
Well, and I'm not going to repeat what the exchange, but you're basing that on how she puts it in 449, are you?
389, my lord, and then 449. So 389, it is the starting point. It is common ground that having and exercising controlling shareholder power does not without more impose liability. So everybody accepted that. If you were just doing the things that you get to do, as my Lord Justice Lewison said to me, that isn't enough. There's got to be a plus factor. It's got to be something more. And the something more that the judge identified is that phrase I showed you, acting in respect of the detailed business decisions and operations of the company. So that was the test that the judge herself found.
Wait a minute, you said acting. That's not what the judge does say.
449, my lord, in respect of the detailed business decisions and operations of
Yes,
the
but
company.
that's not acting. It's using the shareholding power in
Yes.
respect of.
Yes.
You said acting, but that's not what the judge says.
No. So I'm sorry if I misspoke. I'm trying to say that the point is, doing your usual controlling shareholder power things, not enough. It's got to be using the power at that more granular level in respect of that category of decisions.
Yes.
So
Which is what she says.
we'll come on to look at what she says actually happened, yes.
Well, no, I mean, just in that paragraph, you've now correctly summarised that she says exerting the authority in that respect, whereas before you said doing the detailed making the detailed business decisions on the operation. So there's a difference between actually physically doing it and exerting the power in order that it be done.
Yes, my lords, I don't think anybody was suggesting that BHP were doing the actual mining. It was whether or not their involvement in the detailed business decisions and operations amounted to the level of participation that the claimant said it was enough. So the question is, were they exerting the authority to make those decisions? So it follows from this that Samarco's corporate governance structure and the various powers that were held by its controlling shareholders were for liability purposes insufficient. And we say despite this, the judge's liability findings depend to a very significant extent on these very matters. And you can see that in the judgment from paragraph 409. So if we could have a look at that section, which starts from page 94. So this is under the heading, the SSA. This is a section that goes from paragraph 408 and extends all the way to 431. From 409 to 424, the judge sets out the terms of the Samarco Shareholders Agreement, the SSA, and the bylaws. And the conclusion that she reaches is at 425, which is on page 96. And she says there, it is evident from the above provisions that the structure of the governance of Samarco through the SSA and Samarco bylaws enabled BHP and Vale to exercise effective power and control over Samarco. And she then says, if you look at the bottom of that page at 431, that the executive board was subservient to the will of the Samarco board, and that Samarco's corporate governance structure guaranteed the ability of BHP and Vale jointly to control Vale to Samarco. But each of these matters on which the judge relies to support the conclusion there are simply ordinary incidents of controlling shareholder power. So they're exactly... I'm so sorry, my lord.
Why? Why are they ordinary incidents of controlling shareholder power? If I buy shares in a company, I have the right to vote at the EGM and so forth. But that's different. I've entered into a shareholders agreement. I've superadded something to my ordinary rights as a controlling shareholder.
Well, my lord, I don't think anybody disagreed that the framework that was set in place was the framework for the controlling shareholders to share their power. That was not something that was in dispute. And so it was that agreement that set out that framework. So we say that each of those things that she relies on are simply ordinary incidents. And so precisely the matters which the judge found were not sufficient to justify liability. And we can see this error repeated in the immediately preceding paragraphs in that section as well. So if you go up from 431, I stopped at 425, but you can see that there are 5 other examples that she gives there. So for example, BHP and Vale's ability to appoint the members of the Samarco board, which is obviously a paradigm example of controlling shareholder power, and so on. So obviously it was common ground that BHP and Vale together had the controlling shareholder power and were exercising it. And these were, we say, simply ordinary parts of that. If we look then at 525 in the judgment, which is page 111, this is in the section conclusions on responsibility. And here the judge sets out a list of points, and I just want you to look please at that second point, where she finds Samarco's corporate governance structure through the SSA and the Samarco bylaws facilitated BHP's ability to control Samarco with Vale. The SSA provided for appointments to the Samarco board, etc. Executive board is subservient. And she says almost all the decisions of the Samarco board could only be made by their joint agreement. So she's relying on BHP's shareholder powers as an independent basis, a specific reason for her finding of responsibility. And we say that was an error.
Did we go as far as 526, or are we stopping before 526?
Just stopping before 526, my lord. So it's literally just 525 where she makes this finding.
Sorry, what? Why are we stopping at 525?
I'm going to come back to 526. That's the second part of 1.2. So the first part of 1.2 is it was common ground that having and exercising controlling shareholder power not enough. We say she set that out, but she then goes on to actually do the opposite. She actually sets great store by that very thing that everybody had agreed could not give you liability. And we see that she's done that because she singled it out in one of the paragraphs in the conclusions. I'm going to come on to look at how she then applied it, which will involve looking at 526. So we say that this was an error because of the significance that she gave this point. Now, so if I can turn then to that second part, which is ground 1.2b, and this is a failure to engage ground. Now, so as we saw from 389 and 449, the controlling shareholder power has to be used. I'm putting a gloss on the words. I hope everybody knows I'm referring to that bit that I showed you in respect of the detailed business decisions and operations of the company. So we say it was critical for the judge to determine who was making those detailed business decisions and running its operations. Was it Samarco through its executive board, or was it BHP? That was essentially the question. And that in turn, we say, required the judge to engage with the very extensive and compelling evidence that BHP relied on to demonstrate that it was Samarco, not BHP, that was making those detailed business decisions and running its operations. We say that you can't answer the question of whether it's BHP or Samarco without looking at both sides. You can't just look at what BHP were doing and make that decision. It has to be a holistic appraisal of both sides of the ledger. And I just want to use one example to illustrate what happened here. I want to use the topic of the projects, as they were called, compendiously by the parties. That topic represented the high watermark of the judge's findings on BHP's actual exercise of controlling shareholder power. It was the subject of very extensive submissions. It took up 70 pages of our written closing. And I'm going to focus on the P4P project because that was the project of primary importance. Could I ask the court to have a look at Annex 4 of our closings, which is in the supplementary bundle at tab 19. It's N2 1.5. So my lords, this Annex 4 runs to 40 pages. If I could just invite you to just have a literal flick through it to get a flavour for the amount of referencing, because you will see how much contemporaneous documentation is referred to in that document, and it demonstrates that the planning and execution of the project was a matter for Samarco, not BHP. What I just want to show you are some of the diagrams from the documents showing Samarco's control over the project. So the section on the P4P project starts on page 3. And you can see in paragraph 6, at the end of the third line, that major projects were to be developed under the direction of the executive board. So that's Samarco. And then we see this more clearly if we go to the flow chart, which is figure B1 on page 5. And you can see that the title is that it's a Samarco CapEx approval flow chart.
Did you
And this-
say page 5?
5, yes. So this shows how detailed and involved Samarco's internal project approval process was, and the huge amount of work that Samarco did internally to plan and execute its own project. So what it shows in broad terms is Samarco's internal process for the planning and execution of projects, along with the steps that are necessary for the approval of CapEx for those projects. The detail isn't particularly important for our purposes, but I do just want to highlight a few points. So can you see...
In a nutshell, what was project P4P? What was it?
P4P was to build the 4th pellet plant. My lords, can you see in the left-hand column, there's a heading internal forum. Everything listed in that left-hand side is a Samarco body. So you can see the executive board, its project management officer, the general managers, etc. And then all the toll gates, which are in the next column, those are the processes, and the workflow, which is the column after that, that's all Samarco. Now, the Samarco board does have some involvement in these processes, and you can see that from the right-hand side in the final column, which has the heading External Forum. And you can see there are 3 references to Samarco board meeting. And essentially what that is showing is that at the 3 stages of the project's life cycle, the board needed to approve the project. But that's it. You can see that everything to the left of that, all of that planning and execution, is Samarco's responsibility. And what this demonstrates, we say, is the point that I was making to the court earlier about the need to compare what BHP did with what Samarco was doing to come to a procedurally fair result. Because it's obvious, we say, from this flowchart, that what Samarco itself was doing completely dwarfed what BHP was doing. So BHP's participation was limited to the fact that its appointees to the Samarco board had the opportunity to vote on the project as it went through the life cycle. That's what you can see from this. Could I also show you figures B2 to B4? So those are 3 pages which are at pages 7, 8 and 9. And what these are organisational structure charts showing the composition of the project team and people in Samarco responsible for the P4P project at different stages of the planning of the project. And they give you a sense of scale, of how many people were involved and the scale of the planning in the various areas that Samarco was undertaking. All of these are Samarco people. They are not BHP people. Third and finally, B10, which is on page 22. My lords, this is a context map, and this shows the interaction between the P4P project team, which is the big blue box, and Samarco more generally, which is the big yellow box. And you can see that other stakeholders are shown outside the Samarco box. So at the top, you can see government in green, purple is community and NGOs, and then yellow is shareholders. And what this indicates is that the shareholders' role and demands were regarded by Samarco as being fairly peripheral to the project. So in reality, as this and the other parts of this document that I have shown the court demonstrate, the P4P project was a Samarco endeavour.
Doesn't the, does this necessarily help you on the basis that this graphic shows the Samarco Executive Board is providing strategic planning to the P4P project? I think is that what the arrow means on the right-hand side?
Yes.
And the judge found that the executive, in 525, the Executive Board was subservient to the will of the Samarco Board and therefore subservient to the will of BHP and Vale.
Well, my lord, that goes back to the distinction between what you can do as a shareholder, as a controlling shareholder, and what you are doing. That's why that exertion of authority that my lord, Lord Justice Lewison focused on, that's why it matters. It's not enough that you can, in theory, do something. What matters is whether you are in fact doing it.
But the first of that point depends on the structure, doesn't it? When you say it doesn't matter what you can do in theory,
Yeah.
that depends on the structure.
Well, my lord, up to a point.
If it didn't, then you wouldn't even be able to do it in theory.
Well, yes, in order to actually do it, it is true that you need to have the framework that allows you to do it. But the fact that you have the framework that allows you to do it does not mean you're doing it. That was the very question before the court. She needed to ask herself whether there was evidence that we were in fact exerting the authority to make those detailed business decisions and running the operations. But my lords, I took the judge to this document. I took her to these figures. We made submissions, as I've said, spanning 70 pages. None of this was challenged. None of this was challenged. And as the court will appreciate, the detail of what I've just shown you is a fraction of what was contained in the submission. But when I show you the judgment, you will see that none of this is in the judgment. So can I show you her findings on the P4P project? They start at 496, which is PTA 1C 6106. So the heading, we see the P4P project. So 496 refers to BHP Iron Ore's growth strategy in the 5-year plan. There's no explanation of why or how these documents provide any support from the conclusion, which we'll come on to see, that BHP controlled and monitored the P4P project. Then we see, if we scroll down, 500 to 503, that refers to the fact that the Samarco board needed to approve the P4P project. That was uncontroversial. And you can see that these paragraphs refer to the fact that the BHP appointees to the Samarco board required prior authorization from BHP to vote in favour of that project at the relevant board meeting. That prior authorization process was essentially a shareholder due diligence process that focused on the economics of the project and the significance of the process, and in particular whether it amounted to a mechanism by which BHP controlled the planning and execution of the project, was a significant issue at trial. And we therefore addressed this in some detail in our written closing. Can we go to the written closing and then we'll come back to the judgment, because I just want to show you again what we said about this. So that's your supplementary tab 18, starting at page 166, and otherwise it's N2 1.1 166. And if we can pick it up at paragraph 513, so this is the section that I'm showing you where it starts. If we go internally within it to page 168.
513, did you say?
Paragraph 513, my lord, yes.
Of your closing.
Yes. So, para 513 refers to the P4P project IPR. That's the investment peer review, which was part of BHP's internal due diligence process. And you can see that it quotes from a number of the contemporaneous documents recording that it was Samarco's project team that was to conduct studies, planning and analyses of the investment opportunity, not BHP, and that it was the Samarco project team that was charged with preparing the studies for detailing the methodology for project implementation, as well as monitoring and auditing the basic design. If we can go to 514, which is over the page, again, by reference to the documents, it notes that the IPR terms of reference made clear the IPR team would simply review material prepared by the Samarco project team, and that its focus was not on technical or operational matters. And then you see at 515, we make the point that the audience for the IPR was BHP itself. And then from 515 to 518, we highlight that to the extent that recommendations were made in this process, they came from requests from Samarco for support and did not amount to BHP making business or operational decisions. So we explained this and made submissions on it. Now, if we go back to the judgment, we were on page 106.
Just before we do that, is there a specific paragraph in this passage of your closing dealing with the steering committee?
Yes, there is. It is. Perhaps I'll give you the reference for that.
Because I think there was a steering committee, wasn't there, with BHP, Barley and Smart?
There was, and I'm going to come on to look at the passage in the judgment that deals with that. It is, I think it's 245 or 535. Let me just check those, my lord. It's one of those
Of
two
your
references.
closing or the judgment?
Of the closing. I think that was what my lord Justice Fraser was asking
Well,
for.
I was just reading this section of your
Yes, it's
closing.
535.
535.
535 of our closing. In fact, you see there's a heading P4P steering committee at the top of the page. Page 175. And it finishes over the page. And I will come back to look at the part of the judgment that deals with that too. So if I could go back into the judgment, we had looked at 500 to 503, so this is page 107. And if I just ask you to look at this section, you'll see that none of the points that I just showed you in our closing are even acknowledged. And then if we carry on going through the judgment, you can see that what the judge was relying on in support of her finding that BHP was controlling and monitoring the P4P project come down to 2 points. And one of them is the point that my Lord Justice Fraser has referred to, which is the P4P steering committee, and that's addressed at paragraph 506, which is over the page on 106. Now, my lords, this, as we explain in our written closing in the section I've shown you, was a temporary advisory committee to the Samarco board that was established to oversee the project. It also refers this is 506, to the role of Mr. Ferreira of BHP to monitor the project and report as part of BHP's execution phase review, or EPR, which was part of BHP's internal investment process. So that's what the judge says on that. And then at 507, this is the second point that she relies on, she refers to the appointment of Mr. Bill Marshall to the Samarco project team, although there's no suggestion or finding that BHP participated or controlled the project through Mr. Marshall. Now, each of these points was again the subject of detailed closing submission by reference to the contemporaneous documents and evidence, and I showed you the passage in the closings on the steering committee. So there's none of this. None of this is reflected in the judge's judgment, and we say that in and of itself was an error. But the more fundamental error, which in our submission plainly gives rise to an appealable point, is that none of the material in these 2 pages that I've shown you on the P4P project begins to engage with the evidence that was in our 70 pages establishing that it was Samarco that planned and executed and therefore controlled the project. And it appears that in answering the critical question, whether it was Samarco itself who planned and executed the project or whether BHP did that, the judge only engaged with the BHP side of the ledger. She failed to engage with the evidence on the Samarco side of the ledger, and the result, we say, is procedurally unfair. My lords, essentially the same points apply to the other project, so that's the P3P project and P940. And again, we say that the judge didn't look at what was being done by Samarco. It's striking in our submission that the claimants cannot contend that the judge did engage with this material. So what they say, the highest they put the point in their skeleton at paragraph 28 is to assert that the judge was plainly aware that Samarco was involved in the project because the projects obviously concerned Samarco. That does not assist, because the question is not whether the judge was aware in some vague sense that Samarco was involved in the project. The question, as I have said, is whether it was Samarco who planned and executed the project, and there is no indication that the judge engaged with our detailed evidence and submissions in connection with this point. And I emphasize that the material was not challenged. So we don't understand the failure to engage. There are a number of other points that are relied on by the judge. So, for example, Samarco's corporate governance structure, risk and audit, financial investment and benefit, and we've addressed them in our skeleton at paragraphs 36 to 42 and 47. Now, can I just conclude by addressing a couple of points that the claimants make on this? In their para 22, they say that the judge didn't need to determine who in fact was making Samarco's detailed business decisions and running its operations, and that liability could arise even if the decision and operations remained those of Samarco. We do not understand that submission because, as I've already shown the court, that is precisely what is required by the judge's own finding. And even if that point were right, it cannot render a decision fair that we say is procedurally unfair because the judge failed to engage with the material that I've shown you. The rest of the points that are made in their skeleton at paragraphs 22 to 29 essentially amount to either repeating or referring to findings in the judgment and asserting that those findings were justified by reference to their own written closings. And we say again, that obviously cannot render fair a decision that is procedurally unfair. So my lords, that is ground 1.2A and B. Can I now move on to ground 2? Ground 2 is the appeal against the decision that BHP were liable in fault under Article 186 of the Brazilian Civil Code. And we've addressed this in our skeleton from paragraph 61. My lords, unlike the other grounds, this is a pure failure to engage. We say there's been a failure to engage in relation to knowledge and causation. Those were both critical aspects of the requirements for fault-based liability in Article 186. And the structure of my submissions on this ground is going to be as follows. I want to just start by briefly introducing the 7 failures to engage. There are 4 in knowledge and 4 in causation, 3 in causation. So I want to introduce those, and then I want to show you why they matter. So what I'm going to do is I want to show you the anatomy of the judgment and where they come up, so you can understand why it is that I submit that those 7 failures are central to the judge's findings, and therefore why it matters that she didn't engage with the points that we made on them. And then finally, I'm just going to look in detail at some of those examples. So the 7 failures, we've identified the 4 knowledge failures in the skeleton. If we can go to paragraph 64, perhaps I could summarize them. The first is the failure to engage with BHP's case in relation to the contemporaneous documents received by BHP. Thank you. So that is essentially that the judge didn't look at the full content by reference to what we see in the judgment. So, of course, she will have read the document, she was taken to it, but the point is she hasn't engaged with or explained it, given the parts I'm going to show you, which we say were compelling evidence that if she was going to come to a contrary finding, as she did, she needed to then address. So that's the first thing, a failure to engage with the documents that we actually received. The second are documents which we did not see before the collapse. And again, it's important to emphasize that this was not challenged by the claimant, and I'll show you what those documents were later. So there's a universe of documents that we had not seen before the collapse. The judge relies on them extensively in the judgment. And it's not clear how she's relied on them. I will show you and explain our submission on what we think the reliance has been put on them for. But it seems as if she has relied on them in support of a finding that we knew certain things by August 2014. And we say that's a failure to engage with our case about the limits of the information that we had before the collapse. So that's the second knowledge failure. The third knowledge failure is she did not engage with our pleading objection in relation to the claimant's audit negligence allegations. And this is relevant to the judge's findings about constructive knowledge. So her findings about what BHP should have known. The fourth is the failure to engage with BHP's case on the merits of that audit negligence allegation. So we say it shouldn't have been allowed in because it was unpleaded, but once it was allowed in, there was then another failure to actually deal with our points on the merits. And can I just say, just standing back so my lords have it, the audit negligence allegations are relevant to knowledge. The risk management negligence allegations are relevant to causation. And so when I come to look at causation, the 3 causation failures are first of all, and this is paragraphs 80 to 82 of our skeleton, that the judge didn't engage with our case that the applicable causation test could not be satisfied because of the counterfactual chains involved on the claimant's case. So that's causation failure 1. The other 2 causation failures are, again, risk management negligence allegations that were unpleaded. We say the judge didn't engage with our objection. And then the third one is she didn't engage with the merits of what we said about those allegations. So those are the 7 failures. Can I go into the judgment and show you, I hope, why they matter? Could we start, please, at paragraph 650, which is page 134. So it's PTA 1C 6134. Paragraph 650, my lord, page 134. And there's a heading right at the bottom of that page, illicit acts and omissions, the issues. And so if we then look at the next paragraph, the next page, can you see paragraph 652 says that it is common ground that the question of fault in relation to the alleged acts and omissions of BHP. And so the way that this was to be assessed is, as it's set out there, whether BHP knew or should have known at the time relevant to each alleged act or omission that the safety of the dam had been or was being compromised. So that's the key issue.
I'm really sorry, I was checking something on what you said before. Which paragraph are we in?
652.
652.
Yes, my lord, page 135.
No, I've got the page open, I was just looking at 650.
And I was just reading out that last bit.
After the semicolon on the
Yes,
third line.
that's it, precisely. So my lord, that's the key issue, and that immediately raises the question, well, what are the alleged acts or omissions, and which individuals are said to have done them, and when? And the claimant's case on this evolved through the litigation. So in their written opening, they advanced a case that there were 8 so-called illicit acts. Those were very largely unpleaded. They then advanced a different unpleaded case in cross-examination. And by the time of their written closings, they advanced a still different case, and by then it involved 10 imprudent actions. Again, very largely unpleaded. Now, I'm going to come back to the pleadings, but I just want to show you what the judge did, because strikingly, the judge did not adopt the claimant's alleged illicit acts in her own analysis. Indeed, it's fair to say that there is not a structured analysis in what the judge has done, because she has not identified in a systematic way what alleged act or omission she was addressing, by whom and when it was allegedly done, and then analyse what the evidence showed about the overall knowledge. What she did, we can see from paragraph 655. So you can see that at the bottom of the page that we're on. She says, I have found it convenient to consider the material allegations of fault in the following order. And you can see that she sets out a list of 7 topics. I'm going to come back to the detail of each of those, but just so I can show you the overall structure of her analysis, can we go next to page 169, paragraph 801, which is a section headed Conclusions on Fault Liability. And at paragraph 803 in that section, over the page, you can see that the judge identifies 5 things that she says that BHP knew or should have known by August 2014. So on the judge's approach, these are ultimately the critical findings of knowledge on which the finding of fault-based liability rests. And the court will see that although when I showed you the critical issue at 652 as being whether BHP knew or should have known that the safety of the dam had been or was being compromised, there's no actual finding of that in 803. It seems to be implicit in 803.
Sorry, say that again?
So, my lord, in 652,
Yeah.
the judge formulated the critical issue as being whether BHP knew or should have known that the safety of the dam had been or was being compromised. So that was how she put it in 652. But if you look at 803, and these are the findings of knowledge that she has made, that is not reflected there. So I'm saying that we think it's implicit in 803 that that's what she found.
She makes findings about what BHP knew or should have known.
Yes.
Is your point that by making a finding internal drainage of the dam was inadequate to prevent saturation of the sand tailings, it's implicit in that that goes to safety? Because
Well,
that's a fairly basic point on geotechnical structures and drainage.
Not
isn't
just that single point, my lord. I
it? No,
think
but
that
as an example.
that's the whole point. Yes, I'm
Is
simply,
that what you're saying is implicit in
I'm making the point to say I cannot show you a bit of the judgment which reflects 652 in terms, and I'm
The
inferring
precise
that this
words,
is
you mean?
the precise formulation, my lord, the safety of the that matters, as we'll see when we track through how the judges tested that question of what BHP knew or should have known. So it's not a criticism of the judgment, that particular point. I'm just making clear that that's how we've read and understood the judgment.
Yeah.
Well, I think you're right to read it that way, because the last sentence that says the slope would become
Yes.
unstable, you'd have to be an idiot to think that that didn't go to safety.
Well,
wouldn't you?
indeed, all of it, my lord, yes. So what I want to do next is just identify briefly what underpins each of those 5 findings that we see in 803.
Yeah.
Because what I will want to show you is that the 7 failures that I've identified, they impact each of those findings that the judge made on those 5 points. That's why we say that those failures are central.
I know we've asked you a lot of questions, but how are we doing for time? We've got a lot to get through.
We've got a lot to get through, my lord. I'm doing my best. And can I just mention that I'm using those 5 findings just to try and illustrate the point for my lords. One could take all of the findings and do the same exercise. So the first finding is the knowledge of inadequacy of internal drainage. And can we go to 656, which is page 136. So this is the start of the subsection on drainage issues. And you can see that 657 to 660 rely on 3 reports of the ITRB. And these 3 reports are said in the first sentence of paragraph 661, which is over the page, to be the basis for the finding of BHP's knowledge that there were serious ongoing deficiencies in the internal drainage of the dam. Now, those 3 reports relate to the first knowledge failure that I identified for you. So we say the judge, she refers to them, but she doesn't refer to our submissions on what they said and what they meant. And that's important. I'm going to come on to show you an example of them later, because they said in our submission very positive things about the dam. And if the judge was going to make findings that were contrary to that, we say that she should have addressed our submissions on why we said the documents showed the opposite. So the 3 ITRB reports in this section show that first knowledge failure. And we've quoted, just for the court's note, passages of those reports at para 66.1 of our skeleton. If we then look at 662, you can see that the judge relies on a type of document prepared by Samarco called Failure Modes and Effects Analysis. That's the FMEA. And the judge seems to suggest that there was a lack of progress recorded in the FMEA as regards mitigating actions taken in relation to a failure mode called insufficiency of internal drainage. Again, that's our first knowledge failure, because we say, and we've pointed this out in our skeleton at 69.1, that the judge misdescribed the relevant mitigating action for that failure mode in 662. So we say she didn't engage with what the FMEAs actually showed in relation to the implementation of additional drainage by Samarco, and she didn't, therefore, in light of that detail, engage with our case, which was that the FMEAs did not suggest that the safety of the dam was being compromised. So that's, again, a first knowledge failure point. And then if you look at the second sentence of paragraph 662, that refers to another FMEA that is dated July 2015. My lords, that is the second knowledge failure because it shows that the judge relied on documents that we never received. And I'm going to come back and show you the table that we put before the judge explaining what we have seen and what we haven't seen. And in any event, a document dated July 2015 obviously couldn't be relevant to BHP's knowledge in August 2014, which is the finding that the judge made in 803. And can I also flag a couple of causation points here? So 661, you can see from the second part of it, which begins despite this knowledge, and 663, they criticize Mr. Ferreira's approach to the annual risk management processes known as control effectiveness tests. And you'll see reference to CETs throughout. And the criticism is being made of the tests that he did in November 2013 and November 2014. My lords, these appear to be findings of negligence against Mr. Ferreira in relation to his decision to pass the CETs, and they're relevant to causation. And we can see that from the fact that the last sentence of paragraph 663 says that the failure on the part of BHP to recognise the need for and demand remedial action allowed the build-up of a mass of saturated tailings within the structural part of the dam. So the judge implicitly assumes that remedial action would have been demanded if Mr. Ferreira had not passed the CETs relating to the FMEAs.
So instead of assessing them as a pass, it seems to be if he'd assessed them as a fail, then remedial action would have been taken.
Yes.
Is that right?
Yes, but as I'll come on to explain, my lord, we say that there are a further series of steps that the claimants...
I'm sure there were, or would have been, or might have been, but is that your point? Because
Yes.
he assesses these in 2013 and 2014
Yes.
as a pass. And it's effectively said, found by the judge, that that was part of the failure that recognised or meant that no remedial action was recognised.
Yes, my lord has put the point perfectly. Yes, that's exactly it. And so, my lord, this shows that the findings of risk management negligence in the judgment are relevant to what the judge found that BHP should have done on the basis of the knowledge which the judge found that BHP had or should have had. And so that's why, as I said at the beginning, the risk management negligence findings are critical to the causation analysis. So 661 and 663 relate to all three of the causation failures that I identified at the beginning. So the failure to engage with the pleading objection, the failure to engage with the merits, and also the failure to engage with our case, which was that the uncertain counterfactual chain of steps on which the claimant's case relied did not meet the test of causation under Brazilian law. So, my lord, Lord Justice Fraser, the question that you put to me, my lord, what the judge's approach appears to involve is, first of all, a counterfactual demand for remediation from BHP to Samarco, which the judge assumes would have arisen, as you identified, from the failed CET, but then she appears to find, as we'll see later, that that would have implicitly led to some action by Samarco. And that action...
Well, one imagines remedial action, or a decision that remedial action is needed on a dam that's stability threatened, would lead to action by somebody, wouldn't it?
Yes, which would then have prevented the build-up of the tailings, which would then have prevented the collapse. The reason that that matters is because when one looks at the evidence, it's not at all clear that the claimant on the evidence satisfied any of that.
But it's all rolled into, isn't it, the mechanism of failure that she'd found on the geotechnical
It starts, that's where the dominoes start to fall. But I will come back to how the fault relates to the geotech. But in essence, we say that the highly contingent counterfactual chains that the claimants relied on didn't satisfy the necessary causation requirement of Brazilian law. So that's just the first finding that I've just shown you. And I've shown you how it impacts the various failures that we rely on. Can I deal with the second finding, which the judge made in 803, and that was that we knew or should have known in August 2014 that the minimum beach width of 200 metres was regularly violated, and the court may have seen that our skeleton at paragraph 70 explains that the beach width refers to an area of sand separating the crest of the sand tailings from the slimes, which had a prescribed width of 200 metres. Now, the basis for that finding of knowledge is the section which we have on screen. And if we can start with 665, that refers to the 2013 Samarco audit, which is also sometimes referred to as the financial year FY14 Samarco audit. And it is said that BHP made a positive finding in that audit that the beach width was being respected. The rest of the paragraph appears to involve a finding of negligence in relation to the conduct of the audit. And the judge appears to conclude that if the audit had been done competently, it would have identified that the beach width was being regularly violated, and therefore BHP would have known this. So again, it illustrates our third and fourth knowledge failures. That is, failure to engage with our pleading objection to the claimants being allowed to run the audit negligence case, and failure to deal with the merits of what we said about that negligence case. My lords, could I just make clear, in light of the claimant's skeleton at paragraph 47, that there can't be any doubt that this was a finding of negligence about the conduct of the audit. That is clear because when the claimants invited the judge to make a finding that BHP should have identified during the audit a concern about beach width violations, they did so by expressly describing the conduct of the audit as negligent. I just want to give the court references for that, given the fact that they've made this point in their skeleton. It's in their written closings, which my lords have at tab 15, and it's paragraphs 854, 858, 850, 836, 857, 910, and 880. And my lords will see that those paragraphs describe the findings as negligent findings. And so, my lords, the assertion at paragraph 47 of the skeleton that the claimants were not running an auditor negligence case is completely wrong.
So can you just give me those paragraphs again, please? Ms. Mathew?
Yes, my lord, they were in no particular order, but 858, 854, 836.
Just a minute.
Would it be helpful to go through them, my lord?
No, just want the references.
So 858 is one where you will see it says, it refers, in fact, I think it's...
I'm not sure I've got it. My closing goes from para 468 to 1020.
Is that supplementary bundle tab 15, my lord?
Yes.
Ah, could we see if we can get it on screen? It's N1.
Are these 854, 858, etc.? They're all the ones in tab 15, is that right?
They should be. So it's N1, 1.1.1. And could we have a look at 383 to see if we can... 382.
Yeah, right.
I
I can see that they say in 857 it's negligent.
Yeah, my lords, we can provide full copies if it seems you don't have the full copy of the claimant's written
I
closing.
think we've probably got enough to be getting on with.
So I make that point just because of the way that they've put it in their
Yeah.
skeleton. It's completely wrong with respect to say that they weren't running an auditor negligence case. If we then look back in the judgment at 666, this is page 138, you can see that it relies on Samarco presentation materials. And those are said to provide information to repeated violations of the beach width. That again is the first knowledge failure that we rely on. And we've addressed this in our skeleton at paragraph 70, when we explain what the presentations also show. And then the other paragraphs that you can see on the screen, 667 to 669, they again involve findings of negligence against Mr. Ferreira in relation to his completion of the CETs. So that's again, it's all three causation failures. So then the third finding of knowledge in 803 was that the setback had moved the crest of the dam over the slimes and increased vertical loading on the same. It's not clear what the judge relied on for that finding that BHP knew or should have known that there were slimes under the crest of the dam. It does not appear to be directly addressed in the judgment, but so far as we can understand it, on the judge's approach, this further finding follows from the finding that we should have known about the beach width violations, and if that's right, then it suffers from the same problems that I identified there. But if we can look in the setback section at paras 677, which are page 140, and 678, you'll see that again, those paragraphs are relevant to the three causation failures. Here you can see that the judge is dealing with another type of risk management process. So this is the MRCAs. And here the judge appears to find negligence by Mr. Zweig and Mr. Fernandez in relation to those documents by reason of the setback. And again, the implicit finding is that without this negligence in relation to the internal risk management processes, there would have been an undrained stability analysis by Samarco, which would have disclosed the fragility and instability of the dam, which would have prevented the collapse. So that appears to be the way that the reasoning proceeds. Then the fourth finding of knowledge, which I showed you at 803, is that there was no credible liquefaction study or stability analysis obtained by Samarco. And can we have a look at the section which deals with that, which starts at 723 on page 153. And my lord, that begins by referring to the panel report. And as the court will know, this is the technical report prepared by an independent panel after the collapse. And the reference for that is in the judgment at para 56. It did not purport to address BHP's contemporaneous knowledge before the collapse, so it plainly cannot shed any light on what BHP knew by August 2014. You see then that 724 refers to advice from Pimenta de Avila. He was the designer of the dam. And the advice is unidentified there, but it appears to material which is set out in a different subsection of the judgment. This is important because it relates to material that we had not seen at the time. So can I just show you how we've identified it? So it's not identified here, but that formulation, if you just read it at 724, I'm going to show it to you again in paragraph 792, subpara 11 on page 168. Could I just ask you to see it there, please? And the reason...
792, so.
Yes, my lord, and it's the subpara Roman 11, which is on page 168.
Yeah.
So you can see that that's the same formulation, and we infer from this that the judge's material that she's looked at to arrive at that is the material which is set out just above that from paragraph 783 and then 785 and 786. All of those are on page 166. So that is the material that we think the judge is relying on for 724 and 792.11. That matters because all of this material refers to the second knowledge failure. We hadn't seen any of this at the time. So that this input from Pimenta had not been seen at the time. Going back to the liquefaction study that I was showing you, the 724 bit we've just done, 725, this is page 153. 725 onwards to 736 refers to FMEAs. And the judge says that these showed failures by Samarco to make progress in relation to obtaining liquefaction studies. Again, that's our first knowledge failure, because as we pointed out in our skeleton at 69.2, we relied on the fact that the FMEAs recorded progress on their face in relation to the liquefaction studies, and we relied on contextual evidence that it wasn't unusual for these sorts of studies to take a long time. The court will have the refrain, the judge didn't engage with our submissions on that. So that's the first knowledge failure. But then if you look over the page, please, at 154, you'll see at 731, 732, and 736, reference to documents, all of those are our second knowledge failure, because again, we hadn't seen any of those at the time. 737 and 738 again are the three causation failures. They appear to be yet more findings of negligence against Mr. Ferreira in relation to his completion of the CETs. And again, the implication is that absent this negligence by Mr. Ferreira, Samarco would have obtained a further liquefaction study and stability analysis, specifically an undrained analysis, and this would have shown that the dam was unsafe. And then finally, the fifth finding of knowledge that I showed you at 803, that was the seepage, cracking, and movement at the left abutment. And this finding appears to have come from the section which is headed continued increase in the height of the dam, which my lords will see on page 155. It's on screen if we scroll down a little bit. And you can see there at 739 to 740, the judge relies on ITRB report number 11, even though, as my lords know, that is November 2014, so after the August 2014 date that the court found that we had these findings of knowledge. And that's another example of the first knowledge failure. Because again, as I'll show you, that report contained positive observations about the dam. And then finally, can I just show you 807? 807 is the judge's conclusion in relation to causation. My lords, this paragraph is the entirety of the judge's engagement with the issue of how the legal test for causation, that is, the requirement for direct and immediate or necessary causation, was met on the facts. And the court will see that points 1 and 2 do not refer to acts and omissions of BHP at all. They seem to implicitly refer back to what the judge said about the consequences of negligence by Mr. Ferreira in relation to the CETs. Point 3 refers to the failure to do the liquefaction study. Again, that seems to go back to the consequences of Mr. Ferreira's negligence. And points 4 and 5 also presumably flow from those allegations of negligence. But nowhere does this paragraph grapple with the fact that in order to satisfy the Brazilian test for causation, there would need to be a chain of counterfactual steps, and the court needed to be satisfied on the evidence, first, that the failed CET would necessarily have led to the counterfactual BHP action, and if so, what action and when. Second, that this in turn would necessarily have led to counterfactual Samarco action, and if so, what action and when. And third, that this Samarco action in turn would necessarily have led to the collapse being avoided. And again, we say these are all three causation failures typified in this paragraph. So that brings me to the end of the exercise I wanted to do, to show you, rather than assert it, that the 7 failures that we rely on are central. So when I go on to show you what I mean by the judge not taking our submissions into account, I hope the court will have in mind how much those failures impact each of the 5 findings. I've needed to do that to make the centrality point good and to show you how much they bear on that. So can I just now look finally in relation to fault at some of these failures? So could we start with paragraph 64 of our skeleton, please? There we've summarised the claimant's pleaded case. And this is tab 2. Thank you. So the claimant said that BHP received contemporaneous documents which contained advice and warnings about the safety of the dam, and they alleged that BHP disregarded this advice and warnings, and of course we denied this allegation. Our skeleton goes on to say in paragraph 65 that the judge relied on relatively few contemporaneous documents received by BHP. And as you know, the first knowledge failure is that the judge failed to engage with our case in relation to what these documents showed or their analysis. And I just want to show the court the document I've already referred to, which is ITRB report number 11. For the court's note, the judge referred to this report 3 times. So it is referred to in paragraphs 660, 704 and 740. If we can go to the report, it should be tab 46 of your supplementary bundle, and that's D7 121T2. That should be the front page.
Yeah, that's the Opus reference, whereas in the supplementary bundle.
It's tab 46,
Tab
my
46.
lords, I think, of your supplementary.
Okay.
Yes. So we have the front page, we have the date, 20th November 2014. If we can go over the page, we can see the heading at section 2, which is current condition of the Germano Fundão tailings basin. The general operating condition of Samarco's dams is good. The freeboards are adequate, the beaches have the width required in the project, the overflow channels visited are operating properly. There is no significant erosion on the crest slopes or abutments of the dams. The readings of the installed instrumentation are within the expected ranges. Even with the total obstruction of the overflow channels, the reservoir can store the critical rain of 5 days with overtopping in 79 hours. This is a favourable condition for a tailings dam in the operational phase. And then if we scroll down, we see from section 3 summaries of the ITRB activities. And could we keep going to page 12, which is section 13.2. And there's a reference to the August 2014 cracking incident. And then you can see the second paragraph says, an excellent work of retroanalysis and evaluation of the construction was done by Samarco, seeking to explain the rupture mechanism. And there's then a list of lessons learned. And then over the page, you'll see that there are recommendations. But the court will see that there are no concerns raised about safety. And obviously, I've shown you the introduction and how positive that was. And then on the contrary, you can see from the next section, 13.3, that it says the instrumentation is behaving as expected with no reason for concern. And then if we keep going down to page 16, which is section 18, there's a heading general comment. And there we see the complementary reference to Samarco's technical team having matured both in terms of size and composition and in its ability to manage the system. So my lords, 3 points flow from this. First of all, the content of this document points to the opposite conclusion reached by the judge. As I've shown you, the report says in terms that the general operating conditions of Samarco's dams is good. And we quoted that in our written opening, squarely raised it before the judge. We had a compelling case in our submission that the overall understanding of a reasonable reader of this document would have been that the dam was being well managed, not that its safety had been or was being compromised. Second, as you've seen, the report is from November 2014, so it is after the August 2014 date when the court found that BHP knew or should have known that the safety of the dam had been compromised. I showed you that in paragraph 803. Now, third, and despite the date and the content, the judge relied on this document repeatedly in support of her overall finding that BHP knew or should have known that the safety of the dam had been compromised by August 2014. There's no analysis or explanation in the judgment of that, how that finding is or can be consistent with the parts of the document I've shown the court, which are not even acknowledged by the judge. And so we say that this is a material failure to engage with a central piece of evidence and contrary to this court's observations in Symetra, which, as my lords know, is authority for the proposition that if a judge proposes to reach a particular conclusion and there is apparently compelling evidence pointing the other way, then basic fairness requires the judge to deal with that and explain why it doesn't affect her proposed conclusion. But of course, we don't have that in this case. Can I just address a couple of points that the claimants make? They say that the court should assume that the judge had all the passages that we rely on in her mind, and that it would be, they say, fanciful to suppose that the judge had ignored them. That submission does not assist because it raises the key question, and that is, if the judge had them in mind, what did she make of them? And how did she reconcile them with the conclusions that she proposed to reach? We simply do not know, my lords, and that, we say, is the unfairness. And could I also say this, that the court can see from the claimant's skeleton at paras 40 and 41 just how self-serving and unmeritorious their submissions are on the ITRB. On their approach in paragraph 40, whenever the ITRB raised issues about the dam, they are to be taken as raising very serious safety concerns. But on their approach as set out in paragraph 41, BHP was not entitled to attach any weight to their views when they said positive things about the overall safety of the dam. And lords, that is an example of what we said in relation to our first knowledge failure. So I've just shown you one document. I want to now move on to the second knowledge failure, which is, as you'll remember, that we say the judge relied on documents that we had not seen at the time. And we've addressed this in our skeleton, paragraph 72 to 73.
The second knowledge failure.
My lord, yes, the second knowledge failure. And this was a key part of our defence, my lord.
I just saw you check your watch.
Yes.
I imagine it's going to be longer than 2 minutes, is it, your second knowledge failure?
I think, yes, my watch is a little bit different. I thought I had longer, but it's certainly going to take longer than even what my watch says, my lord. So if that's a convenient...
No, I defer to my Lord Justice. I just, based on the thoroughness that you've done your first knowledge failure, I imagined you would be about to embark on a similar exercise on your second knowledge failure.
I will try not to be depressed by the lack of enthusiasm
No,
or my thoroughness.
No, not at all, but it is a PTA application, it's not the appeal.
My lords, it is, and this is why I was concerned when we started with direct indirect, because as you'll see, there is an awful lot of material, and I entirely accept that my lords may be more sceptical about the merits of some of my points more than others. But the critical point that I'm trying to convey is just how much is missing.
Understood. Mr. Chuchai, how long are you going to need?
Well, I'd like to have at least an hour if possible.
All right. Well, in that case, Ms. Fatima, I'm going to have to ask you to stop by 3 o'clock.
I should be able to do that, my lord.
2 o'clock.
All rise available.